I'm Jane Cobb, Executive Director of the SEC Historical Society, and I'm here today, June 14, 2018, with Paul Gonson. Paul, it's nice to see you again, and tell the visitors here what your connection with the SEC was.
Well, for the last 20 years I was there. I was the SEC's solicitor, and in that capacity I oversaw all of the SEC's appellate work in the appeals courts, including the U.S. Supreme Court, and I was also its chief defense lawyer. So when cases were brought against the SEC, I supervised the defense of those cases. But when it came to the SEC in 1961, I was born and raised and started a small law firm in Buffalo, New York, before I came to the SEC. And at the SEC, I was in a variety of positions and worked myself up, so to speak, from a junior lawyer, mostly in the Office of the General Counsel, where prior to my becoming solicitor, I was Associate General Counsel and previously Assistant General Counsel. In my work at the SEC, I handled a great variety of cases and supervised a great variety of cases.
And you have two oral histories in the virtual museum at this point, one from 2006 and the other from 2011. Can you give visitors a flavor of what's in your 2006 oral history?
Yes, that's an oral history in which I spoke about the SEC's insider trading program. And by program, I mean not just a case or two cases, but there's a fraud program and all kinds of other programs. So if you have a cluster of cases and a policy, we call it a program. So the insider trading program was intended to try to bring more fairness into the securities markets. No one wants to play poker with somebody with a rigged deck. They want it to be even and fair. So the philosophical premise for this program was to bring fairness into the market by not allowing people with inside information, by definition not available to the market as a whole, not to be able to benefit from that inside information unless and until the information is given to all in the market. The statute upon which that was based, Section 10b Section 10b of the Securities Exchange Act and Section 10b-5 under that, and those are worded very, very generally. It says it shall be unlawful to engage in deceptive or manipulative acts or practices. And it's hard to tell, well, gee, what does that actually mean? So we use that as in other statutes, but primarily that statute, as a basis for saying that it was a fraud to engage in insider trading that other people didn't know about. So the SEC did this in several ways. It brought administrative cases, that is cases before a hearing examiner in his own building, and cases in federal courts. And in the first 5 cases that went to the U.S. Supreme Court, the Supreme Court reversed lower court cases that held that what was involved was not a security and said, yes, it was. So there was, we called it the expansion area, where they took the definition of security and expanded it. So you get, if you have orange groves with a contract to manage it, that's a security. If you sell pieces of real estate next to an area where they're pumping oil from oil wells, people will think that the adjoining real estate will benefit from the increase in value of that real estate. That was held to be a security. So there are many forms of what is a security that are not only stocks and bonds, and debentures. And the SEC pursued that in the court and eventually got very favorable rulings. So, and of course, most of what we dealt with was with stock and bonds and stock on the exchanges. So the SEC brought a number of cases, as I mentioned, testing those theories and established the principle that if you have inside information that no one else knows about, you must abstain or disclose. Either you have to not trade or you have to disclose it to the market. And the way of disclosing it to the market was generally in a press release or advising the New York Stock Exchange, and they would put out something which would then alert the market. That was a very successful program, and it was also a criminal program. So we brought criminal cases, put people in jail for insider trading. That really focuses attention of the mind when you know that if you get caught, you may have to go to the slammer. So that worked very well, and in the mid 70s, late 60s, early 80s was sort of the heyday of the insider trading program. One of the disturbing things that I've seen was that about 20 years later, in the 1980s, and I was still there at that time, many of the younger people didn't learn the lessons from that 20-year period earlier. There's an old saying that those who are not aware of history are doomed to repeat it. And they did. They developed insider trading of all kinds, sometimes very, very colorful. A lot of books are written about that. And the SEC then, of course, reinvigorated this program, brought cases against them, put them in jail. But all in all, it was a very good program. And in this 2006 oral interview, I go into great detail about the various policies that underlay the program and the various cases that were brought to enforce it. I think it's a very interesting story. And as I said, there are many books written about that insider trading period.
Interesting. So you also did the interview in 2011. Can you give visitors a sense of what they might hear in that oral interview?
Yes, that was an interview that was devoted really to the SEC's role in the courts, not specifically related to any specific program, but how the SEC went ahead in the courts and how it fared in the courts. So I was, as I mentioned earlier, the solicitor of the SEC and his chief defense lawyer from the last 20 years I was there until the end of 1988. During that time and earlier, the SEC brought many cases of all different kinds in the courts. The courts had held early on that the SEC could go to court with its own lawyers and not have to go to court as many other agencies and departments must through lawyers in the Department of Justice or in U.S. attorneys' offices. That made it, I think, better to have the people familiar with the day-to-day operations. And some of these were people who actually worked on those cases. They would then go to court. The exception to that was cases in the U.S. Supreme Court. In those cases, the Solicitor General of the United States, a high official in the Department of Justice, is the government's lawyer in the Supreme Court. And he has a very good staff, and these are very, very capable lawyers on his staff. So when the SEC would have cases in the Supreme Court, it would make arrangements with the Solicitor General to do the first draft of the government's brief, which we would do, and the Solicitor General or his deputies would then edit it or as they felt necessary before it was filed. And his name, Solicitor General's name, and all the SEC lawyers' name who worked on the case would be on the cover of the brief. The Supreme Court then and now takes relatively few cases for argument. It was then taking about 3,000, no, excuse me, it was then being asked 3,000 times a year to hear cases on appeal. And of those 3,000 requests or petitions for certiorari, as they were formerly known, the court would take about 100 cases to hear. However, when the United States government or its agencies would ask to go to the Supreme Court on a case by appealing it, or the loser went to the Supreme Court and the Supreme Court took the case, then the odds of the Supreme Court actually taking the case were 50-50. So there was a tremendous increase in the odds, and most of the time, as I had said, the Supreme Court did take those cases. In the what I would call the earlier years, the Supreme Court was very favorable to the SEC and the SEC's cases. Gradually, over the years, it tended to become a little more restrictive. The SEC would also file friend of the court or amicus curiae briefs in the federal courts, the appellate courts mostly, around the country, and also in the U.S. Supreme Court. Sometimes the court would ask for such a brief. It would issue a one-sentence order to the Solicitor General, which would always say the same thing. The Solicitor General is invited to submit a brief on such and such a case. Solicitor General will always, of course, regard that as a command, to do a command performance. He would then notify the SEC if it was an SEC case, and as I said, we would then go ahead, as I mentioned, draft a brief and send it to him. If it was an amicus case, and most of those cases actually were amicus cases and actual party cases, it was the same procedure. We would draft a brief and send it over there. Some of those cases were criminal cases, that is, cases which were brought in the criminal courts and handled by a top lieutenant of the Solicitor General, who was always known as the criminal deputy. Not that he was a criminal, but that he was the deputy handling criminal cases. And we worked very closely with him as well in the court. In all, it was, I think, at least for us lawyers who practiced there, it was really a wonderful experience to be able to go into the courts and handle these cases of all kinds.
Have you any thoughts about things that you today that wouldn't have occurred to you then, something that you want to share with visitors?
Well, I think that we could have been more proactive and less responsive. I always used to consider some of these far afield matters in which I would want to go to the SG and say, you know, please insert a paragraph in this other agency's case that says so-and-so. I used to call it the Greater SEC Metropolitan Area Interest. And if I had to do it again, I would be more proactive than I was then, because there were cases that would go to the Supreme Court, say from the Federal Reserve System or other financial agencies, the Commodity Futures Trading Commission. And many of those cases, while they weren't directly involved with securities, might have a spillover effect, or a broad area might be construed narrowly. So I would go to the Solicitor General and I would say, I would ask you to put a footnote in that I'll draft that will say so-and-so. And most of the time he agreed to do that. And sometimes it worked magnificently. It'll come to me. It was not a securities case. It was a discrimination case. And they were construing a statute. I thought the government's going to lose that case. So I went and I asked that they put in a paragraph that says that no matter how, oh no, it was an antitrust case. No matter how you construe the antitrust statute, please construe the securities statute this other way. And I pointed out the difference between the securities and antitrust statutes. And he did put that footnote in, and when the case came down, the government lost that case, but there was this wonderful footnote in the Supreme Court opinion which said, this is not to suggest that we would apply the same rule to the SEC. So you see, it worked. And so part of my answer would be, while I was pretty vigorous, I would have been, on reflection, even more vigorous.
Very good. Paul, you were one of the 3 original founders of the SEC Historical Society. Why do you think it's important to preserve financial history?
Well, in part, as I said before, if you don't know your history, you're doomed to repeat it. So it's, in some sense, it's a useful deterrent. But more broadly, I felt, and I think our fellow founders felt too, that there was a need to have a museum of some kind that would collect documents, it would collect regulatory filings, and not only for the SEC, but more broadly with regard to the securities market generally and finance in the United States. And this would be a place where securities lawyers, accountants, members of the financial services industry, scholars, historians, could really look up things, could do research that would be very helpful to their fields. We also thought, in a small way, it would be a nice gesture toward the SEC, which we were all fond of and would like to, give a salute to, so to speak, although we were at great pains to make sure that everyone knew that we were not part of the SEC or an adjunct to the SEC, but we were 100% independent of the SEC, but seeking cordial relationships with them and having programs in their building, and that worked out very well.
Great. Thank you so much, Paul.
You're welcome.